Hey guys, welcome to HipHughes History. We're going to talk it up a little bit about the Supreme Court and just the craziness that's occurred in this presidential election with the unfortunate passing of Antonio Scalia. Of course, it's a humongous deal anytime there's an opening on the Supreme Court. Of course, we know the appointment clause, Article 2, the president shall nominate and by and with advice and consent from the Senate shall appoint judges. They are lifetime appointees. The court decides humongous things. Right now, they're deciding basically the fate of teacher unions, Obama's executive actions in illegal immigration. There's a gerrymandering case, abortion cases. There's an affirmative action case. There's a climate change case. It's just really a big deal. And then add to the mix that the court leans 5-4 to the right, and Antonio Scalia was the giant conservative on the bench, so now we have a 4-4 split. So in terms of pragmatism, with a 4-4 split, the court decision goes to the lower court's ruling. It's like the court never heard the court case. So there will be some decided in favor of the right, some in favor of the left, but we do have kind of a stalemate and a little bit of a constitutional crisis. So with Mitch McConnell kind of throwing the gauntlet down, he's the Senate Majority Leader, and also Chuck Grassley, who's the Republican from Iowa who runs the Judicial Committee, they said no way. It's not going to happen. If he nominates someone, it's going nowhere. They might as well, not bother doing it. The longest wait time in terms of a nomination and then something occurring with that nomination is 125 days. You go back to 1916, Woodrow Wilson, Lewis, Brandeis had to wait 125 days. It was more than 100 days for Robert Bork that Ronald Reagan nominated in 1988 before he was denied. But there actually has been a very long vacancy. You have to go back to Tyler in 1844, where there's a 27-month vacancy on the Supreme Court. But let's talk a little bit about kind of the Republican and the Democratic arguments as they go here. The basic argument is that the Republicans say that Obama is a lame duck, that there should be a popular referendum with a new election because it's such a humongous, consequential Supreme Court appointment, and that it's been 80 years since any president has been able to get a nominee in an election year through. They also point to 1968, when they said that Lyndon Johnson nominated Abe Fortas to be the Chief Justice, and that was successfully filibustered, and that he didn't get his way. This became informally known as the Thurmond Rule, which meant that if the president only had 6 months, that in a sense they were a lame duck. They shouldn't get their choice on the Supreme Court. So that was 6 months. Of course, now we have 11 months. Now, the Democrats, they point to a few things. They say, well, wait a minute. In 1988, Ronald Reagan nominated Justice Kennedy, and he was confirmed unanimously. So there's an example of a president nominating somebody in an election year and getting it through. What they failed to mention is that Reagan actually had 18 months, that the appointment became available in 1987. He nominated Robert Bork. That was about 108 days before he got his vote. He was denied. President Reagan nominated somebody else, but eventually became Justice Kennedy. So the details are a little bit different as that is involved. There is precedent here, believe it or not. In 1852, the last Whig president, Millard Fillmore from my Buffalo, New York, not the humongous badge of honor that it should be, he nominated Ed Bradford to be on the Supreme Court in 1852 during an election year, and the Democrats in the Senate, they didn't let that go anywhere. He eventually, in 1853, in his lame duck, nominated 2 more guys. They didn't go anywhere, and the Democrat, Franklin Pierce, who came in, got his candidate, John Campbell, to be on the Supreme Court. So the Republicans are trying for an 1852. How about that? But their biggest argument, again, is that it's such a consequential, humongous appointment that there should be a popular vote. So what do the Democrats say? Well, they say that, first of all, President Obama is not a lame duck. A lame duck only occurs after an election in the period between that and Inauguration Day. So he's not a lame duck. Number 2, they say that there are 14 examples of presidents nominating presidents in election years and getting them through. But it is correct that you have to go back to 1940 before the last time that actually happened. Frank Murphy, who was nominated and was appointed to the Supreme Court by FDR. They also say that the 1968 example is kind of flawed because Abe Fortas was only being nominated to go to be Chief Justice. He was already on the Supreme Court. And they say that that rule, the Thurmond rule, is 6 months. Obama's got 11 months, so that doesn't fly. That doesn't fly the coop. Is that what they say? That makes no sense. And then the last argument for the Democrats in opposition to the idea that there needs to be a popular vote is that we've already had a popular vote. That the Constitution dictates an election every 4 years. Obama won the Electoral College and the popular vote by more than 5 million votes. So therefore, he is the constitutionally elected president who should fulfill his constitutional duties. 125 days is the longest wait time. Should there really be a wait time of 342 days? So what do you guys think? Leave it down in the comments below. This is a big one. This one is so big, it's huge. It really, really is. Remember, guys, where attention goes, energy flows. We'll see you guys next time that you press my buttons.